So, we have already finished discussing about what a corporation is, um, the nationality, how do we determine the nationality of the corporation, and then the doctrine of separate judicial or separate juridical personality. Um, let's go to another aspect of another doctrines of a corporation in studying corporation law, which is the doctrine of piercing the corporate veil. So, what is this doctrine all about? So, a corporation will be looked upon as a legal entity as a general rule until sufficient reason to the contrary appears. But when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons. So, meaning it's just that the doctrine of separate juridical personality may not be availed of the stockholders composing that corporation. So in the case of PNB versus Retrato Group, GR number 142616-2001, piercing the veil of corporate entity is an equitable remedy developed to address situation where the separate corporate personality of a corporation is abused or used for wrongful purposes. So the general rule is that, so in the case, the case of Kukan versus Reyes, GR number 182-729-2010, discussed the general rule for this doctrine of piercing the corporate veil, on when or how we can avail them. So, so in the case of Kukan versus Reyes, the court held as follows as general rules in applying the doctrine of piercing the corporate veil. First, both the individual sought to be held liable and the corporation must be impleaded at the first instance. So second one, the court must first acquire jurisdiction over the corporation or the corporations involved before each or their separate personalities are disregarded. And the doctrine of piercing the veil of corporate entity can only be raised during a full-blown trial over a cause of action duly commenced involving parties duly brought under the authority of the court by way of service of summons or what passes as such service. So there must be a court proceedings when applying this. So it cannot be the doctrine cannot be veil of or cannot be used by a person, by a natural person, saying that the corporation and the stockholder is just one and the same. In fact, there has been no case filed, or the court hasn't decided that indeed there's the doctrine can be availed of, or the corporate veil can be pierced. So exception of this is the case of Guillermo versus Uson, GR number 198967, wherein the court held that when aggrieved laborer is unable to attach the properties of the corporation, the labor arbiter may thereafter amend its decision by ordering that the individuals responsible be impleaded and their properties levied, provided that such individuals are impleaded and had the opportunity to be heard. So the exception here lies in the fact that even without a court order, the aggrieved laborer may attach the properties, may attach the liability of the corporation to the properties of the said corporation. So in the case of Cruz versus Dalisay, AM number R181-P 1987, a sheriff may not pierce the corporation veil because such powers only belong to the court. The exception lies for the fact of the exception lies usually for labor matters, because in labor cases it's really the labor law and labor code is really for the laborers. That law is created for the benefits of the laborers, for social justice. So the summary procedure, the effectiveness, um, and the way to expedite the serving of the awards in favor of the labor should be done in not to follow the rigid strict rules of court procedures. So the grounds for application of doctrine in the case of China Bank versus DINISEM GR number 149 237-206, the court held that the veil of separate corporate personality may be lifted or pierced when such personality is used to defeat public convenience, to justify wrong, to protect fraud, or defend crime, or as shield to confuse the legitimate issues, or when the corporation is merely an adjunct or business conduit or an alter ego of another corporation, or when the corporation is so organized and controlled and its affairs are so conducted as to make it merely an instrumentality, agency, conduit, or adjunct of another corporation, or when the corporation is used as cloak or cover for fraud or illegality or to work injustice. So cloak. Or to work injustice, or were necessary to achieve equity or for the protection of the creditors. So again, the law, if you're gonna read laws, the laws or the statutes being passed by the legislative department, approved by the executive, by the president, most laws will tends to favor the creditors in such a way that the awards for on how they will collect whatever dues to a debtor. Most laws will has this tool in order for the creditors to somehow had a easier way to collect dues or to whatever obligations that is being that should have been performed by the debtors. So I believe that this tool of the doctrine of piercing the corporate veil is one of the tools being applied or implemented by this law in such a way that the debtors of the corporation will not have a hard time to collect whatever dues or whatever credit or whatever dues or whatever credit that should have been paid off or performed obligation that should have been performed by the corporation as the debtor of the said creditor. So what are the tests? In several cases decided by the court, there are tests that are being used in order to determine if the doctrine of piercing the corporate veil can be availed of. So the following elements must be established to justify the piercing of the veil of corporate fiction under the test that is often used by the Supreme Court, which is called the instrumentality rule, or the three-pronged control test. Okay. So what are these tests? First test is control. So not mere stock control but complete domination. Not only finances but of policies and business practice in respect to the transaction at issue. It must have been such that the corporate entity as to this transaction had at the time no separate mind, will, or existence of its own. Such control must have been used by the dependent commit fraud or wrong, to perpetuate the violation of a statutory or other positive legal breach of duty, or a dishonest and unjust act in contravention of the plaintiff's legal right, and said control must approximately cause the injury or unjust loss of complaint of. So these are the three tests. So first, there must be a control, not only mere stock control, but complete domination. Then the such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of statutory or other positive legal breach of duty, or a dishonest and an unjust act in contravention of plaintiff's legal right. And the third one is the said control and breach duty must approximately cause the injury or unjust loss complaint of. So this is discussed in the case of Concept Builders Inc. vs. NLRC, GR number 10873 for 29 May 1996. Apology for an itchy nose. Anyway, let's continue.
With all the tension I have now in my nerve, this is the result. I am willing to drink apple cider. Kaya nga eh, sinatangahan ko
So, piercing the corporate veil is also used to determine if the parent company of a subsidiary company is liable for any injury caused by the subsidiary companies against a third person. So, in the case of PNB vs. Retrato Group, GR number 142616201, the court identifies the circumstances rendering a subsidiary an instrumentality. So what are these? Circumstances? All right. First, the parent corporation owns all or most of the subsidiaries' capital stock. All right. So, the second one is the parent and subsidiary corporation have common directors or officers. The third one is the parent corporation finances the subsidiary. So the parent corporation finances the subsidiary. So the fourth one is the parent corporation subscribes to all the capital stock of the subsidiary or otherwise causes its incorporation. The fifth one is the subsidiary has grossly inadequate capital. The sixth one is the parent corporation pays the salaries and other expenses or losses of the subsidiary. Seventh one is the subsidiary has a substantially no business except with the parent corporation, or no asset except those conveyed to or by the parent corporation. The third one is that in the papers of the parent corporation or in the statement of its officer, the subsidiary is described as a department or division of the parent corporation, or its business or financial responsibility is referred to as the parent's corporation. The parent corporation uses the property of the subsidiary as its own. 10th one is the directors or executive of the subsidiary do not act independently in the interests of the subsidiary but take their orders from the parent corporation in the latter's interest. And the last one is the formal legal requirements of the subsidiary are not observed. So I believe that the important these are some of the manifestations, some of the circumstances that we can that the court held or identifies or circumstances rendering a subsidiary an instrumentality. Here you goes. Successor corporation rule in relation to piercing the veil of doctrine rule. Successor corporation rule in relation to piercing the veil of doctrine rule. So, when a corporation fails this, there are cases that a corporation will be dissolved and then there's a successor corporation. What did the court rule when it comes to successor corporation in relation to piercing the veil of doctrine rule? So the court says that when a corporation feigns dissolution or secession, but really continues in existing organized under another name, the application of the rules figures prominently in labor cases where the prior entity seeks to evade its obligation to its laborer. Some telltale signs exhibited in Claparols versus CIR GR number L3082297 that include ownership and control by former controlling stockholders and turnover of assets. So it's kinda noisy around, but let's be patient with the environment. Again, I'm I want to choose to review to this such such environment in order for me to be not bored or in this way. This also my practice, since if I can review in such kind of environment, or I can understand my lessons, or I can understand my notes if in this kind of such chaotic or noisy environment, then I can do it inside the environment. So let's continue. What is trust fund doctrine? In the case of Bowman Environmental Development Corporation versus CA, GR number 7860/1988, the court held that trust fund doctrine states that the capital, stock, properties, and other assets of corporation are regarded as equity in trust for the payment of corporate creditors. So again, the trust fund doctrine states that the capital, stock, properties, and other assets of a corporation are regarded as equity in trust for the payment of corporate creditors. So equity in trust for the payment of corporate creditors. So all funds received by the corporation in payment of the shares of the stocks shall be held in trust for the corporate creditors and other stockholders of the corporation. So no fund shall be used to buy back the issued shares of stock except only in instances specifically allowed by the corporation code, or by the revised corporation code. So effect of the trust fund doctrine. So what's the effect of the trust fund doctrine? So in the case of Philippine Trust Company versus Rivera, GR number L19761/1923, the court held that the dividends must never impair the subscribed capital stock and must only be declared out of unrestricted retained earnings or worth. So in the case of Philippine Trust Company, where the dividend must never impair the subscribed capital stock and must only declare out of unrestricted retained earnings. Subscription commitments cannot be condoned or remitted. So cannot be condoned or remitted. General rule, in the case of NTC versus CAGR number 127-937-1999, the court held that the corporation cannot buy its own shares using the subscribed capital as the consideration therefore. Exception as in the case of Onion versus GR number 144476203, redeemable shares may be acquired even without surplus profit for as long as it will not result in the insolvency of the corporation, or in the cases that the corporation conveys its stocks in payment of a debt, or in a closed corporation, a stockholder may demand the payment of the fair market value of the shares regardless of the existence of retained earnings for as long as it will not result to the insolvency of the corporation. So again, in a closed corporation, a stockholder may demand the payment of the fair market value of shares regardless of the existence of retained earnings for as long as it will not result to the insolvency of the corporation. Again, in a closed corporation, a stockholder may demand the payment of the may demand the payment of the may demand the payment of the fair market value of shares regardless of existence of retained earnings for as long as will not result to the insolvency of the corporation. Just highlight that. Rescission of subscription agreement is not allowed since it will effectively result in the unauthorized distribution of the capital assets and property of the corporation. So, rescission of subscription agreement is not allowed since it will effectively result in the unauthorized distribution of the capital assets and property of the corporation. Since it will effectively result in the unauthorized distribution of the capital assets and property of the corporation. So, yung rescission of the not allowed. Rescission of the subscription agreement is not one of the instances when distribution of capital asset and property of the corporation is allowed. Exception to the trust fund doctrine when distribution of corporate capital is allowed. So the trust fund doctrine first initiated by this court in the 1923 in the case of Philippine Trust Company versus Rivera is the underlying principle in the procedure for the distribution of capital assets embodied in corporations, which allow the distribution of corporate capital only in 3 instances. So there's distribution of corporate capital is allowed in only 3 instances. So number 1 is amendment of the AOI to reduce the authorized capital stock. So amendment of the AOI to reduce the authorized capital stock. Second is the purchase of the redeemer shares of the corporation regardless of the system of unrestricted retained earnings. And number 3 is the dissolution and eventual liquidation of the corporation. So dissolution, purchase of redeemable shares for the corporation. So when you purchase the redeemable shares, it's regardless of the existence of unrestricted retaining earnings. So in the case of Donina Haley versus Printwell Inc. GR number 157-549-2011, the court held that the trust fund doctrine is not limited to reaching the corporation's unpaid subscription. A corporation has a legal capacity to release an original subscriber to its capital stock from the obligation of paying for his share in whole or in part without a valuable consideration or fraudulently to the prejudice of the creditors. So the creditor is allowed to maintain an action upon any unpaid subscription and thereby steps into the shoes of the corporation for the satisfaction of its debt, and to make out a prima facie case in a suit against stockholders of an insolvent corporation to compel them to contribute to the payments of its debt by making good unpaid balances upon their subscription. It is only necessary to establish that the stockholders have not in good faith paid the issue price of the stock of the corporation. Again, So, in the case of the Nina Haley birth sprinter, the court held that the trust fund doctrine is not limited